Nolle prosequi is legal term of art and a Latin legal phrase meaning be unwilling to pursue, a phrase amounting to do not prosecute. It is a phrase used in many common law criminal prosecution contexts to describe a prosecutor's decision to voluntarily discontinue criminal charges either before trial or before a verdict is rendered. It contrasts with an involuntary dismissal. Application in law. Nolle prosequi as a declaration is most often used in criminal cases, but in jurisdictions making use of nolle prosequi in civil lawsuits, is used by a plaintiff to voluntarily drop its claims. In civil cases, a motion for voluntary dismissal may be made by a plaintiff instead of a declaration of nolle prosequi, depending upon the custom and rules of a given jurisdiction. Decision maker. Nolle prosequi as a declaration can be made by a prosecutor in a criminal case either before or during trial, resulting in the prosecutor declining to further pursue the case against the defendant. Courts seldom challenge applications for nolle prosequi. In the U.S., judges will usually sign a dismissal order prepared by the prosecution or make a docket entry indicating the disposition of the case to be nolle pros after a declaration or motion by the prosecution. In criminal cases in the U.S. it has been held improper for a court to enter an order of nolle prosequi on its own without a motion by the prosecutor, but as to sentencing discrepancies involved in a sentence recommendation, a trial judge is authorized to reject an underlying guilty plea based upon concerns of fairness and justice or because it is presented after the plea cutoff date. The notes to Rule 48 of the U.S. Federal Rules of Criminal Procedure, FRCRP, draw attention to the effect of the rule as contrasting with common law. Rule 48 now mandates that prosecutors seek leave of the court before dismissing a case via filing a nolle prosequi. Reason: the declaration may be made because the charges cannot be proved due to evidence too weak to carry the burden of proof, because the evidence is fatally flawed in light of the claims brought, or may be made if the prosecutor becomes doubtful the accused is guilty or the defendant's innocence is proved, or if the defendant has died. It has also been used when a federal criminal charge is brought up against a defendant and the prosecutor on a state charge for the same offense no longer wishes to pursue the case. Usually this happens when the state prosecutor is content with the sentence on the federal charge and has no need to go any further with the original case. Timing: in criminal cases, nolle prosequi declarations are generally made after an indictment as long as adjudication on the merits has not occurred, or in some jurisdictions, as long as a trial has not commenced. In civil cases, nolle prosequi declarations are made either before trial begins or before judgment on the merits is rendered, depending on the rules of the jurisdiction. Legal effect: the entry of a nolle prosequi is not an acquittal, and the principle of double jeopardy therefore does not apply. The defendant may later be re-indicted on the same charge. Application in civil cases: in civil cases, a nolle prosequi or a voluntary dismissal may be entered as to one of several counts or claims, or as to one of several defendants, or both. In any jurisdiction, whether a motion for voluntary dismissal is used or a declaration of nolle prosequi, federal and state rules of civil procedure generally govern when, how and for what reasons claims may be voluntarily dismissed, applying different rules to different types of claims, and to whether a court may give leave to dismiss a matter with or without prejudice. Effect on future employment: federal agencies, especially the military, view nolle prosequi as an unfavorable judgment. This has the effect of requiring a waiver submission for service, or the outright denial of employment. The overuse of nolle prosequi as a way to get individuals to assist in the prosecution of other cases has given it a negative view by the federal government for employment purposes. Similarity to a declination of prosecution: nolle prosequi is similar to a declination of prosecution, which is an agreement not to prosecute made before any charges are brought or suit has been filed. A declination of prosecution may be made by an attorney, but also may be made as an agreement between the aggrieved party and the claimant. In contrast, nolle prosequi is usually made after a decision to prosecute has already been made. A declination of prosecution may be made for many reasons, such as weak evidence or a conflict of interest.